This is Barry Zalma on insurance. Today I'd like to go again into the creation of the tort of bad faith, which started in 1958 in a case called Comunale versus Traders in General Insurance Company, which was decided on July 22, 1958, and whose decision was written by Chief Justice Gibson of the California Supreme Court. The text of the case and the decision follows. Mr. and Mrs. Comunale were struck in a marked pedestrian crosswalk by a truck driven by Percy Sloan. Mr. Comunale was seriously injured and his wife suffered minor injuries. Sloan was insured by defendant Traders in General Insurance Company under a policy that contained limits of liability in the sum of $10,000 for each person injured and $20,000 for the accident. He notified Traders of the accident and was told that the policy did not provide coverage because he was driving a truck that did not belong to him. When the Comunales filed suit against Sloan, Traders refused to defend the action, and Sloan employed competent counsel to represent him. On the second day of the trial, Sloan informed Traders that the Comunales would compromise the case for $4,000, that he did not have enough money to effect the settlement, and that it was highly probable the jury would return a verdict in excess of the policy limits. Traders was obligated to defend any personal injury suit covered by the policy, but it was given the right to make such settlement as it might deem expedient. Sloan demanded that Traders assume the defense and the settlement of the case. Traders refused, and the trial proceeded to judgment in favor of Mr. Comunale for $25,000 and Mrs. Comunale for $1,250. Sloan did not pay the judgment, and the Comunales sued Traders under a provision in the policy that permitted an injured party to maintain an action after obtaining judgment against the insured. This is California Insurance Code, Section 11580, parentheses B, close parentheses, parentheses 2, close parentheses. In that suit, judgment was rendered in favor of Mr. Comunale for $10,000 and in favor of Mrs. Comunale for $1,250. This judgment was satisfied by Traders after it was affirmed in Comunale versus Traders in General Insurance Company. Comunale obtained an assignment of all of Sloan's rights against Traders and then commenced the present action to recover from Traders that portion of his judgment against Sloan which was in excess of the policy limits. The jury returned a verdict in Comunale's favor, but the trial court entered a judgment for Traders notwithstanding the verdict. The following questions are presented on Comunale's appeal from the judgment. 1. Did Sloan have a cause of action against Traders for the amount of the judgment in excess of the policy limits? 2. Was Sloan's cause of action against Traders assignable? And 3. Was the cause of action barred by the statute of limitations? In determining whether Traders is liable for the portion of the judgment against Sloan in excess of the policy limits, we must take into consideration the fact that Traders not only wrongfully refused to defend the action against Sloan, but also refused to accept an offer of settlement within the policy limits. It is not claimed the settlement offer was unreasonable in view of the extent of the injuries and the probability that Sloan would be found liable, and Trader's only reason for refusing to settle was its claim the accident was not covered by the policy. Because of its wrongful denial of coverage, Traders failed to consider Sloan's interest in having the suit against him compromised by a settlement within the policy limits. There is an implied covenant of good faith and fair dealing in every contract that neither party will do anything which will injure the right of the other to receive the benefits of the agreement. This principle is applicable to policies of insurance. Citing to a case called Hilker versus Western Auto. In the Hilker case, it is pointed out that the rights of the insured go deeper than the mere surface of the contract written for him by the defendant, and that implied obligations are imposed based upon those principles of fair dealing which enter into every contract. It is common knowledge that a large percentage of the claims covered by insurance are settled without litigation, and that this is one of the usual methods by which the insured receives protection. Under these circumstances, the implied obligation of good faith and fair dealing requires the insurer to settle in an appropriate case, although the express terms of the policy do not impose such a duty. The insurer, in deciding whether a claim should be compromised, must take into account the interest of the insured and give it at least as much consideration as it does to its own interest. When there is a great risk of a recovery beyond the policy limits, so that most reasonable manner of disposing of the claim is a settlement which can be made within those limits, a consideration in good faith of the insured's interest requires the insurer to settle the claim. Its unwarranted refusal to do so constitutes a breach of the implied covenant of good faith and fair dealing. There's an important difference between the liability of an insurer who performs its obligation and that of an insurer who breaches its contract. The policy limits restrict only the amount the insurer may have to pay in the performance of the contract as compensation to a third person for personal injuries caused by the insured. They do not restrict the damages recoverable by the insured for a breach of contract by the insurer. The decisive factor in fixing the extent of Trader's liability is not the refusal to defend. It is the refusal to accept an offer of settlement within the policy limits. Where there is no opportunity to compromise the claim and the only wrongful act of the insurer is refusal to defend, the liability of the insurer is ordinarily limited to the amount of the policy plus attorney's fees and costs. In such a case, it is reasoned that, if the insured has employed competent counsel to represent him, there is no ground for concluding that the judgment would have been for a lesser sum had the defense been conducted by insurer's counsel, and therefore it cannot be said that the detriment suffered by the insured as the result of a judgment in excess of the policy limits was proximately caused by the insurer's refusal to defend. This reasoning, however, does not apply where the insurer wrongfully refuses to accept a reasonable settlement within the policy limits. Most of the cases dealing with the insurer's failure to settle involve an insurer who had assumed the defense of the action against the insured. It is generally held that since the insurer has reserved control over the litigation and settlement, it is liable for the entire amount of a judgment against the insured, including any portion in excess of the policy limits, if in the exercise of such control it is guilty of bad faith in refusing a settlement. Those cases that so find, of course, factually distinguish from the present one, since traders never assume control over the defense. However, the reason traders was not in control of the litigation is that it wrongfully refused to defend Sloan, and the breach of its express obligation to defend did not release it from its implied duty to consider Sloan's interest in the settlement. We do not agree with the cases that hold there is no liability in excess of the policy limits, where the insurer, believing there is no coverage, wrongfully refuses to defend and without justification refuses to settle the claim. An insurer who denies coverage does so at its own risk, and although its position may not have been entirely groundless, if the denial is found to be wrongful, it is liable for the full amount, which will compensate the insured for all the detriment caused by the insurer's breach of the express and implied obligations of the contract. Certainly, an insurer who not only rejected a reasonable offer of settlement, but also wrongfully refused to defend, should be in no better position than if it had assumed the defense and then declined to settle. The insurer should not be permitted to profit by its own wrong. A breach which prevents the making of an advantageous settlement when there is a great risk of liability in excess of the policy limits, in the ordinary course of things, result in a judgment against the insured in excess of those verdicts. Section 3300 of the Civil Code provides that the measure of damage for a breach of contract is the amount which will compensate the party aggrieved for all the detriment proximately caused by the breach, or which, in the ordinary course of things, would be likely to result from it. It is clear that Section 3300 of the Civil Code authorizes a recovery in excess of the policy limits, and in our opinion, there is no merit in traders' contention that Section 3358 of the Civil Code so qualifies Section 3300 as to prevent such a recovery. Section 3358 provides that a person cannot recover a greater amount in damages for the breach of an obligation than he could have gained by full performance. The question is, what would Sloan have gained from the full performance of the policy contract with traders? If traders had performed its contract, it would have settled the action against Sloan, thereby protecting him from all liability. The allowance of a recovery in excess of the policy limits will not give the insured any additional advantage, but merely place him in the same position as if the contract had been performed. It follows from what we have said that an insurer who wrongfully declines to defend and who refuses to accept a reasonable settlement within the policy limits in violation of its duty to consider in good faith the interest of the insured in the settlement is liable for the entire judgment against the insured, even if it exceeds the policy limit. In addition, the court dealt with the assignability of the cause of action and stated, an action for damages in excess of the policy limits, based on an insurer's wrongful failure to settle, is assignable whether the action is considered as sounding in tort or in contract. Traders relies on a clause in the policy provides that an assignment of an interest under the policy shall be binding only if traders consents thereto. However, it is well settled that such a provision does not preclude the transfer of a cause of action for damages for breach of contract. This rule has been applied to provisions against assignability in insurance policies similar to the provision here. Therefore, there is no problem assigning the cause of action. Sloan's cause of action against the insurer arose on August 13, 1950, when the judgment in the bodily injury action became final. The complaint in this present action was filed on May 28, 1954, less than 4 years but more than 2 years after the cause of action arose. Traders contends that an action on an implied obligation arising out of contract is not on the written instrument and that therefore the 4-year term prescribed in Section 337 of the Code of Civil Procedure is not applicable. We do not agree. The promise which the law implies as an element of the contract is as much a part of the instrument as if it were written out. Traders relies on a statement in Scrivener v. Woodward that promises merely implied by law and not supported by any express promise or stipulation in the written instrument do not fall within the provisions of Section 337 relating to contracts in writing. This statement is too broad, and it was limited in O'Brien v. King as applying only to quasi-contractual liability. Although a wrongful refusal to settle has generally been treated as a tort, it is the rule that where a case sounds both in contract and tort, the plaintiff will ordinarily have freedom of election between an action of tort and one of contract. An exception to this rule is made in suits for personal injury caused by negligence where the tort character of the action is considered to prevail. But no such exception is applied in cases like the present one, which relate to financial damage. The judgment is reversed with directions to the Superior Court to enter judgment on the verdict. This decision started the tort of bad faith, which has gone on for almost a century and has been, like the insurers who abused the Comunales, begun to abuse insurers. And it is important to read and listen to the entirety of the case so that you can understand as an insurance person or a person seeking coverage under an insurance policy why the tort of bad faith was created and why perhaps it might be time to reconsider it. This video was prepared from the decision itself by the California Supreme Court, which is also available in part in many of my books on insurance claims, including the standard treatise, Zelma on Insurance Claims, in 10 volumes. If you found this video to be interesting or useful to you and your colleagues, please pass it on. It's free. And please subscribe to my YouTube channel, my Rumble channel, my blog, and my Substack publication so that you can learn of future videos and future blog postings. Thank you for your interest and attention.